So thank you so much, everyone, for joining us tonight for a special Advocacy Grand Rounds with Doctors for America. Today, we'll be talking about the public health implications of this past Supreme Court term, and boy, are there many. So before we get started, I just want to take a quick minute to invite those of you who are clinicians or clinicians in training to officially join Doctors for America. Being a part of DFA means that you be able to take part in important conversations around the future of public health and really the future for our patients and trying to improve health and healthcare. And also, being a part of DFA also means requires just selecting a membership level, paying annual membership fees to support DFA's organizational sustainability. And we'll have a DFA member who will put a link to join in the chat. We're going to be live streaming today, again, on Facebook Live, and also making a recording, and all the materials will be available afterwards. A few ground rules for this session today. There's no such thing as a stupid question, and especially as all of us who are clinicians and not lawyers, we're very lucky to have such an esteemed panel of experts to talk to us about the public health implications of these very complex Supreme Court cases and being able to understand what this means for us in a practical level. Speaking of questions, please remember to use the Q&A feature. We will also address your questions during the second half of our session, and also look out for comments in the chat, and DFA staff will be sharing helpful links during the session. Now, on to tonight's panel discussion. We're thrilled to welcome three amazing attorneys and legal experts here with us today. So first, we have Rachel Sachs, who is a professor of law at Washington University in St. Louis. She is a scholar of innovation policy, exploring the intersection of health law, food and drug regulation, and patent law, and her work analyzes problems of innovation and access to new healthcare technologies. Her scholarship has appeared in several peer-reviewed journals and also medical journals, including the Duke Law Journal, NYU Law Review, Michigan Law Review, Harvard Law Review, New England Journal of Medicine, JAMA, and Health Affairs. And she recently served in the Biden-Harris administration as a senior advisor for the Department of Health and Human Services Office of the General Counsel in the Center for Medicare and Medicaid Services Division. She's testified before the United States House of Representatives Committee on Energy and Commerce and the House of Representatives Committee on Ways and Means, and she serves currently as a non-resident fellow at the Brookings Institution. And we also have Carrie Flaxman, who's a senior legal advisor at Democracy Forward, and she joined Democracy Forward after nearly 2 decades as a litigator and legal advisor for Planned Parenthood Federation of America, where she most recently was Planned Parenthood Federation of America's Senior Director of Public Policy, Litigation, and Law. Over the course of her career, she has served as lead counsel in a number of trial and appellate matters at the state and federal levels, winning victories that maintain and improve access to reproductive health care services against difficult odds. We're very grateful for Democracy Forward's work in this space and their collaboration on several amicus briefs that we've filed as DFA and the Reproductive Health Coalition on some of the cases I'll be talking about today. At Democracy Forward, Ms. Flaxman supports the organization in crafting legal strategies to advance the rights of all people and to stop attempts by state and local government actors to undermine our democratic values. And last, and certainly not least, we have Allison Zeev, who's the Director of Public Citizen Litigation Group and of the Group Supreme Court Assistance Project. Founded in 1972, the litigation group is a litigation arm of the nonprofit consumer advocacy organization Public Citizen, which is our leading consumer advocacy organization in this country. Her practice addresses administrative law, consumer health and safety, access to court issues, the First Amendment, and open government. And she's argued 5 cases before the Supreme Court and many more before federal district and appellate courts. In addition to litigating, she serves as senior member of the Administrative Conference of the United States, a member of the American Law Institute, and judge of the American Constitution Society annual Cudahy writing competition on regulatory administrative law. She's taught courses as an adjunct professor at Yale Law School, Georgetown University School of Law, and American University's Washington College of Law. She's a graduate of Brown University, go Bears, and Yale Law School. So thank you so much to these 3 folks who are speaking today. Just by way of context, DFA this past term has been engaging in judicial advocacy, and partly because we've been seeing these various threats that are going through the courts outside of the typical spaces that we operate, which is usually in legislatures or with other policymakers and federal agencies, and just seeing how judges are kind of superseding the expertise of scientists, clinicians, and others that serve in these federal agencies to make decisions about public health and the health of our patients. So because of that, we've been engaged on judicial advocacy through amicus briefs, really making folks in our DFA membership network aware of what's happening in the courts and how it's going to affect our patients. So we thought it was very important that we have kind of an overview and a debrief of this past Supreme Court term, given that there were several cases that affect health and healthcare and really how we practice medicine. So we're very grateful for folks on this call who are here today joining us, and especially to our speakers who are going to be explaining to us the nuances of all these different cases. So I'll hand it over to Ms. Sachs.
Thank you so much for bringing us all together. Can everyone hear me up or down? We're good with the audio, perfect. Unlike my co-panelists, I'm not a practicing attorney, but as a law professor, I spend a lot of time thinking about these topics and these cases. So I'm going to simplify them just a little bit in the interest of time, hoping we can get to some more specific questions later. So at the end of June in Loper Bright Enterprises versus Raimundo, a 6-justice majority of the Supreme Court overruled the 40-year-old Chevron doctrine, which is the doctrine under which courts defer to reasonable agency interpretations of ambiguous statutes. And the majority grounded its logic in the text of the 1946 Administrative Procedure Act, basically saying that under that law, courts are not permitted to defer to agencies' interpretation of statutes, but that those interpretive decisions belong to the courts themselves, even in cases involving technical statutory interpretation questions. One question is, with Chevron overruled, what replaces it? It's not completely clear from the decision. So the majority cites several times to one case called Skidmore, which talks about situations where we give greater persuasiveness to agency interpretation under certain circumstances, such as when the agency has thoroughly considered the issue, when its arguments have been consistent over time, but the majority doesn't want to call it deference, so it's unclear how much work that's doing. The court does explicitly contemplate that the best reading of a statute may be that Congress has delegated authority to an agency to fill an interpretive gap or exercise its discretion. So they say Congress may have specifically empowered an agency to prescribe rules, or they use examples of cases where Congress has used words like appropriate or reasonable that suggests that there's deference for the agency, or that there's room, I should say, for the agency to think about what might be a good policy. And in cases like those, the Chief Justice Roberts, in his majority opinion, he says the job of the court is to make sure that the agency is exercising its authority within those delegated boundaries. He uses the word respect rather than defer, as in courts must respect that delegation. But he doesn't provide as many details as we might like as to how to know when such respect is appropriate and how far such respect should go. I do want to say something about 2 other cases, or 1.5 other cases. The court decided this term before stepping back to draw a couple of more general lessons about this. So Loper Bright is not the only case the court decided this term that limits the power of the administrative state. So the day before Loper Bright came down, a 5-4 majority of the court issued a decision which basically said that the EPA had not sufficiently responded to public comments in its finalization of a particular environmental protection rule. The substance of the decision appears to increase the scrutiny that the court will apply to agencies receiving public comments during the regulatory process. But there's a split on the court. It's hard to see exactly under what circumstances that's likely to be the case. And then the second case came down right after Loper Bright. It's called Corner Post. And essentially, Corner Post is about the statute of limitations applicable to lawsuits brought against the United States. It had been thought that regulated parties had 6 years from the issuance of a final rule to challenge that rule. Corner Post says a claim under the Administrative Procedure Act doesn't begin to run until a particular plaintiff is injured by the action, not when the rule is issued. And so what that means is that rules can now be subject to challenge decades after they were issued. You can imagine a new plaintiff or a newly formed plaintiff challenging some of these older rules. And so the combination of these cases goes far beyond just Loper Bright itself. The court has opened the door to new challenges to old rules. It's given more authority to courts in interpreting the statutes that lead to those rules. And it's told courts to scrutinize agency rulemaking more closely when you look at all three cases together. So just a couple of very brief takeaways from these decisions. First, the court is taking power from Congress and the executive branch and giving that power to itself. Congress and the executive branch have been legislating and making rules in the shadow of Chevron for 40 years, and the court wipes all of that history away. Second, it's hard to overstate the potential uncertainty involved as a result of this opinion. So some generalist administrative law scholars have argued that it's possible something like Chevron deference is recreated in the lower courts if you adopt a robust reading of some of that language about respect for agency interpretations. But it's harder to draw that conclusion if you're looking at the rhetoric of the opinion and also at these other opinions the court is issuing simultaneously. And then third and finally, before I turn it back over to Reshma, uncertainty is bad for highly regulated industries, including in the healthcare context. It's hard to make important business decisions if you can't rely on what an administrative agency has said about what the rules are, if you don't know the conditions under which you can practice medicine or run a hospital or engage in any of these types of activities. So for now, there's a tremendous amount of uncertainty and there's very little clarification of these decisions. Thank you.
Thanks so much, Rachel. I'm going to turn it over to Carrie, who's going to be talking to us about the reproductive health cases that came before the Supreme Court this term.
Yeah, hi, everyone. I think everyone probably heard a lot about the two abortion cases that were before the court this term. So I'm just going to do sort of a high level summary of what happened and a few takeaways. So the two cases were the Food and Drug Administration versus the Alliance for Hippocratic Medicine, which is the case involving mifepristone and its approval and conditions of use by the FDA. And the second case is Moyle versus United States and Idaho versus United States, which is the case about what EMTALA requires providers who are subject to EMTALA to provide in a case of a more extreme abortion ban. And, you know, I think one of the interesting things is, of course, the court really thought they were getting out of the business of deciding abortion cases. And so it's, you know, not surprising to me, having followed this for years, but I think perhaps surprising to the court that they had not one, but two abortion cases before it this year. And both cases pretty much ended up, I would say, as a draw, with most of the questions and the merits of these cases left unaddressed by the court, and will be addressed in the lower courts, and the cases will, you know, no doubt come back to the Supreme Court, if not next term, then after. In the FDA case about mifepristone, the court held properly and 9-0, so no dissents, that the plaintiffs in that case, who were anti-abortion individual physicians and organizations, didn't have standing, which is a legal injury that you need to come to court. And you can't come to court if you don't have the right kind of injury to sue. And the court said that these doctors whose complaint was essentially because of actions that FDA has taken, and then actions that another provider has taken, and in consultation with the patient taking the medication, if those patients do end up coming to hospitals with complications, and the doctors claim to be injured by having to treat those patients, the court said that that's just too attenuated to be the kind of injury that courts should address. And that is absolutely the right decision. I think the thing that's notable about it is that that case was filed in November of 2022. And, you know, it took until June of 2024 to resolve that piece of the case, when if it had been filed, I think in any district court other than the Northern District of Texas, or in the Fifth Circuit, where, you know, Reshma said at the outset, we have courts who are ideologically motivated, no longer deferring to science and expertise. But if it hadn't gone through those courts, it would not have seen the light of day, certainly would not have made it all the way up to the Supreme Court. And so that case was sent back down to the lower court for further proceedings. Nothing has happened yet. But even though those plaintiffs did not have standing before the Supreme Court ruled, Judge Kaczmarek, who is the trial court judge, allowed 3 states claiming to have injury from the approval of mifepristone, allowed them to intervene in the case. And so those 3 states have pledged to continue the fight. And so when proceedings do resume, we would expect to see the challenge continue. And so the risk that the case poses to the approval and to, in particular, the removal of the requirement more recently that the medication be dispensed in person, that case still continues to pose a risk to the availability of mifepristone. The second case, the case about EMTALA, obviously the mifepristone case, if mifepristone is removed from the market or if mifepristone is required to be dispensed in person, will have really extreme impacts on provision of abortion care and miscarriage management in this country. The EMTALA case is about a very small number of abortions every year. And is, I think, a sign of, the extreme abortion bans in these cases, and advocates doing what they can to try to make sure that patients who need care are able to get it. This case actually arose out of, it's a case that the Biden administration brought against the state of Idaho right after Dobbs. Idaho's extreme ban on abortion only allows abortion if the patient's life is threatened. And EMTALA requires that participating hospitals provide stabilizing treatment to a patient experiencing an emergency medical condition. An emergency medical condition is defined more broadly to include risks to health. And so, the Biden administration argument was federal law requires abortions if an abortion is a stabilizing treatment that is necessary to treat an emergency medical condition, and those conditions might be health-threatening and not just life-threatening. Because of that, federal law trumps state law. And the lower court agreed with the federal government and entered a limited injunction that allowed providers in the state to provide care essentially when a patient in an EMTALA situation required an abortion to preserve her health, but it wasn't clear that it was necessary to preserve her life. And I don't have to tell you how it's very difficult clinically to make those decisions. So it was kind of in a strange posture, but going before the court, but the court ended up reaching out and taking the case before it had really worked its way through the lower courts. And at the same time they took the case in January, they also blocked the injunction that was allowing some additional abortion care in Idaho. It came out at oral argument that as a result of the injunction being blocked by the Supreme Court, St. Luke's Health System, which is the largest hospital in Idaho, had to airlift 6 patients. That was between January and April when the oral argument was. So the court, when it decided that case, the end of June, issued actually a 1-line order that said, basically, we made a mistake and shouldn't have taken the case in the first place. It's they dismissed the writ of certiorari as improvidently granted, which essentially means we thought we should take this case. As everyone knows, the court doesn't take all the cases before it. They take a small number of cases a year. And they said the factors that we usually consider, we shouldn't have taken this case. And they also blocked, they allowed the injunction to go back into effect, putting the case back where it was when the court took the case. And that is in the Ninth Circuit Court of Appeal. There's going to be additional briefing going on now. There's going to be oral argument in December. But there were essentially three groups of justices, because there were additional opinions. The group that was believed, or at least asserted in the opinion, that they made a mistake in taking the case in the first place. The opinion was written by Justice Barrett, and she essentially said, well, the case has changed a lot since we took it. The Idaho Supreme Court has weighed in. It became clear there were a lot of factual questions, and there are some important legal questions, and we want this all to play out in the lower court, not weighing in on the merits. Although I will say that it was notable being in the oral argument, because you could almost see the light going off in Justice Barrett's head when she realized that the state was saying to the court that in cases of PPROM, that Idaho law didn't permit an abortion. And I think she believed that it was okay to uphold the Idaho law and get rid of the injunction, because she believed that medically necessary abortions, as she saw them, and she seemed to think PPROM indications was one of them. It was as if, it really was that they didn't, the factual record wasn't played out. And then the other two opinions were basically the three liberal justices asserting what is the correct view of the statute, which is essentially federal law does require abortions in cases that are banned under state law, and that the federal law should prevail. And then Justices Alito Thomas and Gorsuch, their opinion ascribes meaning to some language in the statute involving unborn child, which was an amendment soon after EMTALA was passed in the 1980s, that made clear to hospitals that if the patient is stable, but the fetus is not, you still have to treat that patient. The conservative justices take that language, though, to mean that there's actually a duty to the fetus in the statute, and in their view that Idaho should prevail. So again, a draw, and despite it seeming like we would have one or two blockbuster abortion cases, we spilled a lot of ink, and there were a lot of resources invested, and we're going to continue to see these cases battled out in the lower courts. As Reshma mentioned, Doctors for America filed amicus briefs in both cases, which is, it is, there was a really incredible amicus showing in both cases in support of the federal government. So I will pass it back.
Allison, I'm just going to turn it over to you to talk about the broader implications and other things that are weaving their way through Congress.
So I'll start where Carrie finished with the. Also, I want to apologize if I look like I'm getting a mugshot taken. It was hard to find a quiet space in my house at 8 o'clock at night, and I feel like I'm in a lineup or something. But I'll start where Carrie finished with the EMTALA case. There were a number of legal theories advanced in the case about why Idaho should be able to ignore EMTALA, or about why EMTALA required overriding some of Idaho's statute. And it did seem during oral argument that Justice Barrett was very frustrated with the lawyers on Idaho's side, because there's inconsistency in the briefing, and she thought maybe more was allowed, and then the statute actually allows, and the state clarified during argument that it wasn't allowed, that the life of the mother doesn't actually matter, or the health of the mother. So she was frustrated by that, which I think gave some hope that she was on the government side. But there were a number of arguments in the case, and one thing that I found concerning, and that I think we're gonna see again, so EMTALA is a spending clause statute. That is, it's a statute that Congress enacted using its power to spend money as opposed to its Commerce Clause power, which is its power to regulate commerce throughout the United States or between the states. One of the newer arguments that people who are opposed to having the federal government be able to adopt and enforce strong federal protections for health and safety, among other things, is that when Congress legislates using its spending clause power, for some reason that's sort of like second-class legislation. I'm not exactly sure where they get this, but we're seeing it now in a number of cases. And so, though generally under the Constitution, when there's a conflict between state and federal law, the Constitution says federal law always wins, which was basically the government's argued in this case, in the EMTALA case. This spending clause theory is that, like, well, maybe not if it's spending clause legislation, because that's sort of like second-class legislation somehow. In one of the separate opinions, when they dismissed the case, the Chief Justice and Justice Barrett indicated significant interest in this issue. And it is one of the issues that's going to be litigated back in the Court of Appeals this fall. And it gave me significant concern after thinking that Justice Barrett might be on the side of women in this case, that maybe she'd found a different way to sort of overlook the implications and rule in favor of Idaho. So I'm pretty concerned about that. And then the spending clause theory, we're also seeing it turn up in some other cases, challenging various things by various agencies, including the Department of Health and Human Services. So it may very well be a specific issue before the court when the EMTALA case from Idaho winds its way back there, which, as Carrie said, could be next year. I think that there's sometime in 2025, the Ninth Circuit will rule, and whoever loses will petition the Supreme Court again. The mifepristone case, also the EMTALA case, it also has just broader implications, I think, beyond reproductive care, because if Idaho's theory is correct, then any state could choose to effectively opt out of EMTALA for whatever type of procedures or indications that it preferred to opt out for. I don't see how the court could make a special rule for abortion, and the arguments haven't suggested anyone saying it's a special rule for abortion, but there are judges and Supreme Court justices who, or maybe all of us, who view the law through like their personal ideological or political views. And so the outcome, because this case is about abortion, may wind up being very damaging for EMTALA's protection of patients who come to emergency departments with all sorts of conditions that require immediate stabilization. So from that depressing summary, going back to the mifepristone case, again, that case was just about abortion, or about the specific abortion drug. But I think it also, if it is allowed to advance, if the courts decide that the states have standing to pursue the case, then the implications for judicial review of FDA decisions and maybe other agencies' decisions, I think is really troubling. The case is actually about the procedural way it winds up in court is that this group of people submit to FDA a citizen petition, which anyone can submit at any time to the FDA, and then FDA will give you an answer. You petition the agency, maybe some or all of you know this, but you petition the agency, you send in the document, you say, I'm requesting the agency take the following action. Here's all the relevant information that you need that supports what I'm saying, and please give me an answer. So a group of anti-abortion physicians submitted this citizen petition. It was 14 pages, double spaced, and they wanted the FDA to reconsider some of the decisions it made to make access to mifepristone less restrictive, decisions made in 2016. And also some of the petition was just saying, in the future, don't do other things that hadn't been done yet. The FDA took several years to respond, super frustrating. Public citizens submit citizen petitions all the time, and the FDA sometimes takes a decade, super frustrating. But anyway, when the FDA responded, it had 40-some pages of single-spaced analysis explaining why it was denying the petition. None of this is really part of the Court of Appeals decision, and it's not really the focus of the analysis in the Supreme Court. Normally, what one would expect as a lawyer litigating regulatory cases against regulatory agencies is if you're challenging an agency's sort of fact-specific decision about whether to approve a product or how to regulate a product, that the courts would be very deferential to the court's fact-finding. There's even in the Food, Drug, and Cosmetic Act, I think it specifies that if a company challenges the FDA's disapproval of a new drug application, that the court should review that for give the agency's fact-finding substantial weight. And there's lots of case law, including by Justice Kavanaugh, that acknowledges that agency's fact-finding is subject to substantial weight. It doesn't mean they're always right, but that you that the court should assume that on these specific factual matters, the agency got it right, unless somebody can show that they're just wildly wrong. But in the mifepristone case, nobody was even looking at the full record. There were over 1,000 pages of expert reviews from the FDA about mifepristone, the medical officer's review, the pharmacologist's review, a chemist's review, epidemiology. There were tons of reviews. We added them up, cited them in our amicus brief. Nobody was looking at that stuff. The courts weren't looking at it. The district court in Texas and the Fifth Circuit were willing to override the FDA's decision without even evaluating or even looking at the very substantial record on which the FDA made its decision. Instead, sort of looking at this 14-page double-spaced document. If the Supreme Court had followed that path, I think that would be an extremely troubling outcome, worse than the overriding of the deference doctrine that Rachel described. So it didn't go there, but as Carrie described, both cases are sort of dodged a bullet that is still in the air. I'm not sure where that metaphor went, but we still don't know what's going to happen in either case. So maybe they won't wind up making law that has really scary ramifications for all sorts of cases, and also the FDA's ability to do its job in general. But we don't know that yet. So we can be hopeful without being quite optimistic, I think. I am supposed to move on to talking about what's going on in Congress. So there are several bills in Congress trying to address things that happened in the Supreme Court this year. More of the cases that Rachel talked about than Carrie. So there are bills in the House and Senate called the Corporate Capture Act that have lots of things that deal with how agencies function, but specifically both have provisions that would restore the doctrine of deference to agencies' views of the statutes that Congress directs them to administer. There are bills in the House and Senate worded differently from one another that are short standalone bills that would just restore a statute of limitations for challenging agency action, because the corner post decision that Rachel described effectively eliminates the statute of limitations for a wide variety of cases. That case doesn't apply to every agency action by every agency, because there are some statutes with the like the Clean Air Act that have a very specific statute of limitations, or if you want to challenge an agency, an FDA disapproval, there's a specific statute of limitations. But for a large amount of what the FDA does and HHS in general, the statute of limitations is affected by this corner post decision. So the bills in Congress would make the statute of limitations 6 years. In my view, it should be far less. Trying to convince I'm a litigator, but trying to convince my colleagues who are lobbyists to lobby for 180 days. Either way, they're placeholder bills. I think no one really expects them to happen before November or even before January. But they're there and Congress is talking about them, and that's good. There is no bill right now addressing the EMTALA case because we don't really need one, because there was no decision, and what we really want is to EMTALA to just be enforced according to its terms. I think that's it for the bills. There are some other that are talking about other aspects of administrative law. For instance, there's some talk about how do we stop every single case from being filed in Texas and going to the Fifth Circuit. Those are trickier and worth thinking about. And I've seen some drafts, but I'm not sure any have been introduced yet.
Thanks so much, Allison. I'll move it over to Rachel about what Congress is trying to do through legislation in anticipation of these cases, or as a result of these cases.
Yeah. So I'll first speak generally, and then I'll talk about some more specifics that would be applicable to the healthcare context. So in general, remember that Congress is a co-equal branch of government, and it has the opportunity to use legislation to reassert its control over legislation, over implementation of federal programs. And that might look different in different contexts. So in Loper-Bright, the various ways in which Chief Justice Roberts talks about potential areas of respect that they would award to agencies, those sound in different terms, those can manifest in different ways in different contexts. So for example, in some situations, it might be appropriate for Congress to use terms like appropriate or reasonable more frequently. In other situations, particularly as it relates to definitions, specifically noting that agency officials, whoever they may be, have authority to promulgate regulations to define such terms, to specify related details, would be important. There are lots of phrases that already exist and Congress has familiarity with using in this context. This is to say nothing of the bills that Allison has just mentioned, right? There are various pieces of legislation that would seek to overturn overturn Loper-Bright entirely, things like that. Now, I do want to put this aside. There were some concurring opinions in Loper-Bright that raised questions about whether the decision is completely a statutory one or whether there may be a constitutional basis for it on separation of powers grounds. So there are at least a couple of justices who might not view favorably a decision overturning a piece of legislation overturning Loper-Bright. So some of these more specific interventions could be more useful, at least as it relates to the healthcare context. So in the healthcare context, there's a few different options or a few different even advantages that people on this call or listening may have for supporting the work of members of Congress and their staff going forward. I think in the FDA context, some of this work might be a little bit easier as a procedural matter than in some other areas. And the reason for that is that every 5 years, we have an UFA cycle. We have a user fee cycle. And In the past, those have often had 60 votes in the Senate. They haven't needed to go through the reconciliation process. And so that establishes a built-in legislative vehicle to do some of this work. And there may be fewer questions about exactly what can go through as a matter of reconciliation through the parliamentarian. So in the CMS context, it may be a little bit more difficult. I defer to people who are more closely watching particular congressional matters about whether appropriations bills might be a possibility here. They may be more challenging, but every 5 years we do have an UFA cycle, and I think the next one is just kicking off. As far as 2027 seems, I think there are some discussions, with that already getting started. So another thing that particularly, Congress can think about doing, and this group can help in particular, is to think about ways to increase Congress's own expertise. Because one way to potentially respond to Loper Bright and these related cases is to think about ways in which Congress can be itself a bit more of an expert and delegate a little bit less to executive agencies, or have a clearer sense of where delegation might be needed and where it can reserve some of these decisions for itself. And so there's a range of processes that Congress can use to support itself in developing that expertise, because like administrative agencies, Congress is often underfunded when it comes to substantive and technical expertise. So one thing that Congress could do is it could use the technical assistance process, right? So agencies often offer congressional committees advice about particular pieces of legislation. That process could be used to think about where delegation might be appropriate, about where some of these statutory terms could be addressed. That could be more useful to agencies. People may not always know where this is likely to happen, but it could be in some cases foreseen in advance. You could also think about using the expert staff at MedPAC and MacPAC. Unlike in a lot of other substantive areas, Congress has real substantive expertise in a lot of these federal healthcare programs. And so using or thinking about whether it's possible to draw on the expertise of the staff of those legislative agencies could be helpful. And then another one is all of you, the people on this call, the people sort of watching later on, there are real opportunities to help provide technical expertise and support these legislators and their staff as they're moving towards the development of many of these pieces of legislation. I think back to Allison.
Yeah, I'm just turning back to Allison to talk about kind of what's coming through the courts, kind of as a result of this past term, and kind of what will end up in the Supreme Court in relation to administrative law.
Carrie, you may want to jump in on some of these too. As I mentioned, the EMTALA case, the mifepristone case may come back, and they may raise different sorts of administrative law issues. So the mifepristone case would probably raise the same issue it raised the first time, minus standing, or maybe including standing. There are a bunch of cases that are sort of fleshing out the consequences of the Loper Bright decision, or of another case called SEC versus Advocacy. In these cases, the groups that are challenging federal regulations are trying to argue that the decisions that the court issued last term have sort of the broadest possible ramifications. So although the Loper Bright decision leaves room for deference to agency decision-making in various situations, as described earlier, there's a lot of arguments now that there's no deference at all. Although the court also said that earlier cases that ruled for an agency by deferring to the agency's interpretation remain good law. There's a lot of arguments now being made that that's not true. So asking courts to disregard earlier precedent. Today, the Sixth Circuit decided the Sixth Circuit Court of Appeals is in Ohio, Kentucky, and some other states. It decided a case today, Tennessee, called Tennessee versus Becerra, where the state of Tennessee was challenging HHS's decision to, HHS said that Tennessee was no longer in compliance with the terms of a grant because of under Medicaid, because the terms of the grant required that if a woman asked for advice about abortion, the provider had to give it. And Tennessee said, we've decided that we only have to give advice to the extent consistent with state law. And since abortion is not available under our state law, we don't have to give that advice anymore, which violated the terms of the grant. In arguing that the termination was improper, the state invoked Loper-Bright and deference doctrines, and to argue that the state shouldn't get any deference. It made arguments about the scope of the agency's authority because it was a spending clause statute, argued that the agency didn't have authority to state the terms of a grant, even though the statute specifically said that the agency could make the terms of the grant. But the court said no and ruled for HHS. These sorts of arguments, though, really challenging everything that agencies do. We're gonna keep seeing them, and we do keep seeing them. A lot of them are brought by Republican state attorneys general. So that's why we have, the EMTALA case is Iowa versus this case was Tennessee versus, and we're going to see a lot more of those. There are several challenges now to turn on a case that follow on to a case that we hadn't dealt with, but I think are in the lower courts and may lead to further cases in the Supreme Court. Last year, the court held that it was a violation of the Seventh Amendment right to a jury trial in civil cases for the SEC to adjudicate an enforcement action using agency administrative law judges, even though the company or person who was the subject of the enforcement action could then appeal the decision to a federal court. The Supreme Court said that it had to be done in federal court from the beginning. That also applies to other agencies that do in-house adjudication, like the Federal Trade Commission. We're seeing a number of, there's a couple of cases already trying to expand that ruling to Department of Labor adjudications that are like a pretty different contexts. So each decision that we see, we're now seeing other states or other challengers try to expand on them. And the last one I'll mention is a case from last year in which a company argued that the Department of Labor's Occupational Safety and Health Administration lacked, that it wasn't constitutional for it to issue health and safety standards under the statute, because the statute said the agency should issue standards as necessary and appropriate for workplace safety. And the argument was that was too broad, and that broad delegation violated the Constitution. They lost that case, which is specifically contrary to longstanding Supreme Court authority, but Justice Gorsuch is quite interested in that issue, and I think they certainly have his vote for it. So although that one challenge lost, it is we're definitely going to see that repeated several times. It just seems like crazy to me to be opposed to workplace safety standards, but that's where we are.
Carrie, you want to tell us a little bit more about kind of what's happening on the reproductive health landscape? It's
Yeah.
gonna lead its way to the Supreme Court.
Sure. So, in addition to the EMTALA and mifepristone cases, which are going to likely come back again, Allison just mentioned the case involving the state of Tennessee's grant. That is part of the Title X family planning program. And it is related to the gag rule litigation, the gag rule that has gone back and forth. There was a gag rule under Reagan that those of you who've been doing this as long as I have will remember was upheld by the Supreme Court in Russ versus Sullivan. And there was a new gag rule imposed by the Trump administration that was largely upheld. But this is the issue is whether Title X providers can or must counsel pregnant patients about all of their options, or whether there is a gag rule that bans those Title X providers from offering non-directive options counseling to pregnant patients. Now, interestingly, so there's an underlying case that is ongoing in Ohio challenging the Biden rule that requires Title X providers to provide non-directive options counseling. And it turned out that the best friend that that the government HHS had was the Chevron doctrine, and in fact in Russ versus Sullivan, because in Russ versus Sullivan, the Supreme Court said that the Title X statute, which bans abortion as a method of family planning in the Title X program, that was ambiguous, and so at the time deferred to the Reagan administration's gag rule. The Sixth Circuit, I believe was earlier this year, but what's time, said that they were going to uphold the Biden rule, requiring Title X providers to provide counseling and referral in the program because of Chevron. And so now with Chevron overturned, there's a legal question about what Title X, what the HHS is going to be able to require of Title X providers, even though for the most of the 50 years that program has been in existence, over 50 years, providers have been required to give non-directive options counseling to pregnant patients, as is consistent with the standard of care. So that is something, unfortunately, to look for. That is probably not great news. I know we want to get to questions, so I will end on sort of two more positive sets of cases that are moving their way through the courts and may result in some improved access to care. One is that there are two cases pending now, both of them in the Fourth Circuit Court of Appeals, one out of West Virginia and one out of North Carolina, where in West Virginia, Gen Biopro, the manufacturer of the generic mifepristone, and in North Carolina, a provider, Dr. Amy Bryant, have sued the state of North Carolina and West Virginia, I got that backwards, but respectively, challenging their abortion restrictions as preempted by the federal, by the FDA, essentially by the FDA REMS. And the West Virginia case did not result in a victory in the district court, but the North Carolina did result in half of a victory. The district court there said that some of North Carolina's restrictions on mifepristone were preempted by federal law. So again, those cases are going to be argued probably, well, at some point this fall, this winter, and the hope is that the Fourth Circuit will at least affirm the North Carolina opinion. But the real hope is obviously that the court will see that FDA approval of this medication has preempted state laws that are more restrictive. And then I also wanted to mention that there are longstanding cases, a number of them, that have challenged the FDA REMS because, as we know, mifepristone is safe and effective and should not be subject to a REMS. Unlike the FDA Alliance for Hippocratic Medicine case, those cases have a full FDA record in front of it. So the problem that Allison identified, one of the many problems, as Allison identified with the Alliance for Hippocratic Medicine cases, there was no actual administrative record before the court. Those cases have the full administrative record. And the hope there is that the courts will, end up finding that those REMs are not medically appropriate and that the agency overstepped. So, there's a lot uncertain out there, but at least some cases where advocates are still advancing cases. As someone recently said to me, you have to keep swimming. So.
And thank you so much to all of you. We have a couple of questions in the chat. One of them being, is there a need for mounting stronger support, including in splitting industry ranks, to find a legislative approach to correct the overturning of Chevron deference? If so, are there promising areas where litigation in the near term might show the shortcomings of the Loper-Bright decision in a way that industry itself would realize it would be better to have the certainty of Chevron deference? And, feel free to, talk about kind of one of the first post-Chevron cases related to lab developed tests. I'd be curious, how that weaves into this sort of answer as well.
Yeah, we didn't mention the
I'm gonna
challenge to
maybe
the. I was just going to say, we didn't mention that there's a challenge to the FDA rule about the about testing, and there's also a challenge to the FDA's decision not to approve certain vaping products. That one's in the Supreme Court, and it also is a very fact specific, actually, like the mifepristone case should be, really reviewing the agency record. Sorry, Rachel, you're up.
Well, I was going to say that one potential impact of Loper-Bright is for there to be more circuit splits if you have the same rule that's challenged in various places around the country. So scholars have argued that Chevron had a calming effect on the lower courts, right? If they thought the statute was ambiguous, they would defer to the agency. Now you might have different courts reaching different interpretations, which often happens, of the same statutory language. They'll be making those decisions themselves. And so one effect of Loper-Bright is for there to be more circuit splits and potentially more cases going to the Supreme Court for its resolution. One concern that arises at the intersection of Loper-Bright and Corner Post is that some of these circuit splits might not arise for a very long time. So you could imagine that a rule comes out, it's challenged in one circuit, that circuit upholds the rule, and then a decade later, there's no circuit split, so the Supreme Court never rules on it. A decade later, the same rule is challenged in another circuit, which is no longer bound by Chevron, no longer needs to give deference to the agency. That circuit court reaches a different interpretation. Now, all of a sudden, you have a delayed circuit split arising. That type of uncertainty, not just whether a particular rule will be upheld or not, but an uncertainty that persists over time, over years, and perhaps over decades in light of Corner Post, that can be potentially really destabilizing. So we haven't seen this happen yet. I think it's unclear exactly in what circumstances this might arise, but you could imagine that the Supreme Court very soon is going to be asked to weigh in on a lot more of these statutory interpretation questions. Whether it even has the docket ability to handle them, I think, is a separate question. So there's a lot of different areas in which this could arise.
One consequence of the way things were before June is that most regulatory cases never went to the Supreme Court. They would be decided in the Court of Appeals. One reason they didn't go to the Supreme Court so much is that the agency would win more, so it was less important for the Supreme Court to review it. And the other is that there wouldn't be conflicts among different circuits because the cases were usually in DC, but if they weren't, they were just one other place. People weren't litigating till they found the right court, and it would all happen pretty promptly after the decision. So one change in what we've seen over the past few years, but I think we'll keep seeing it, is a lot more cases about agency action that are going to the Supreme Court. Maybe I'll also add that we can take advantage of these cases to some extent too. The Chevron doctrine is a pro-government doctrine. And when we don't like what the agency's doing, Chevron is not our friend. When we do like what the agency's doing, Chevron is our friend when we're in court. So to the extent an agency now issues a regulation that we think is bad or inconsistent with the statute, we litigate that without the agency having the benefit of Chevron. Or to the extent there's a rule from 10 years ago that we've always hated, but we knew we couldn't win because of Chevron, we could challenge that now. I'll say that we're actually looking to sort of figure out if there's older rules that we want to challenge. But one hesitancy we have that I think maybe the Republican state attorneys general don't, is that we do see some value in like consistency and stability of the regulatory system. So even if we didn't like a rule, if it's 10 years old or 20 years old, there's often some value in letting it be. So
just as a kind of a last sort of question or like to all of you, I think for us as clinicians who are not as engaged in the courts, but seeing the ramifications of these cases kind of coming through and seeing kind of the courts being used in a way to kind of set public health rules, to regulate or to put boundaries around agencies, it's very concerning. And it seems like there's like an onslaught of these cases. There's like this strategy to kind of find courts where these cases will be accepted, and where there might be favorable decisions that will lead to deregulation or threats to public health, or kind of limit reproductive health access, much less access to other forms of healthcare. And so I'm curious, like kind of maybe the silver lining a little bit about like what can clinicians do, folks who are in this space, to be able to fight back against this. Are there efforts, and I think some of this was mentioned in terms of like litigation that might be actually good litigation or more proactive litigation in this space to kind of right size or to kind of get back to some of the public health values and make sure that those are kind of instilled and codified by judges in some ways. Trying to find the kind of the silver lining in all of this for all of us, because it doesn't, the term overall did not seem great, at least for public health. And so would love to kind of hear maybe some optimism or, at least some inspiration of like what we can do.
I mean, I can hop in and there's also a question in the chat that I can quickly answer, I think probably in my response, which is, and you mentioned this, Reshma, too, is amicus briefing has been, I mean, it's always important. I think it's particularly important when you are going to have courts deciding to rule without the benefit of a record. In this case, it happened. The question is why there was no administrative record before the court in the Alliance case. And the short answer is it was just too soon in the case. It was at a preliminary stage of the case. The record is produced further on. And so the court was litigating whether there should be a preliminary injunction. And at that point, early in the case, there's not the full record, which should be assigned to the court to sort of step back, but that didn't happen here. But it made the amicus briefs all that more important, because the briefing, the government wrote a strong brief, Danco, the manufacturer of mifepristone, but they only had so many pages, and also they themselves didn't necessarily have the scientific expertise. And so if courts are not going to be deferring to the government agencies, clinicians have a really significant role in making sure that the courts hear from experts.
I think that's true. I think that, judges, maybe even lawyers, have this idea that they like are smart and know everything, and what's before them is all they need. And sort of, particularly when you're a Supreme Court justice, like people have told you your whole life you're really brilliant, and now you've got this job that confirms it. So to have doctors saying like, this is actually how things work, this is actually what this means, this is actually what the facts are, I think that can be really valuable. There was I'm not sure it's appropriate for the court to look at information that's not in the record that comes up to it from the lower court, but this Supreme Court doesn't mind. So in the case about bump stocks this term, for example, they relied on some drawings in some amicus brief about how triggers work and like incorporated that into the opinion. It seemed to me just once you put that sort of specific factual diagram into an opinion, to me, that's a trigger, that it's a sign that that case should not be in the Supreme Court. That's not what the court should be doing, but they're doing it. So put in a brief the details in a physician-like way, that like not trying to talk to lawyers, but talking like you're a physician. I think that shows that like this is how things actually work. This is what we really look at. In the mifepristone case, our brief tried to talk about what, not the facts of the record, but the extent of the record and how that wasn't like, that's what you would look at. You shouldn't be overturning these things without looking at the record. But a brief that actually went through the record, I think that sort of thing can be valuable. At least give them pause about what they're doing. Like they don't like to be wrong. Once they do it, they'll never admit they were wrong. And also once they say something is true, then it by definition is true. But you all as physicians can give them pause that like maybe we need to actually think about what the facts are.
And just to extend that point, you can help judges understand what the stakes of an opinion or what the stakes of a particular case are. What is likely to happen in the world if we rule for one side or the other? And in some cases, it will be very clear. In other cases, it will be much more complicated and technical and very difficult to understand. And you can help bring clarity to some of these complex issues. And even if it's a case where the judges disclaim reliance on the consequences or disclaim the importance of the consequences to their decision, if they say, well, we're not focusing on what's likely to happen, we're just doing statutory interpretation, those decisions, they're now the responsibility of the judges. They're now being made by judges in a way that previously they were being made by experts at administrative agencies, they were being made by Congress. Now the judges have responsibility more directly for these cases and helping them realize the stakes of the responsibility they've taken for themselves and what the impacts will be, I think is valuable.
Thank you so much. We'll end on that kind of hopeful note. Just want to thank, close tonight by thanking everybody, including our speakers, for this very thought-provoking discussion. We're so grateful that you took time out of your busy schedules and especially at night to join us and to be able to educate us about these cases and their implications. Before everybody leaves, just a couple of quick announcements. Because voting is now considered a social determinant of health, please think about your voting plan for Election Day and that of your medical students and residents if applicable. And studies have shown that physician voting is 14% lower than the general population. And as we've heard today, who sits as kind of the head of the executive has huge implications for some of these federal agencies and the rules and regulations that come forward. And so that's something also to keep in mind as we think about these Supreme Court decisions. A DFA team member will put some excellent resources in the chat for your consideration to be able to set up a voting plan in collaboration that we're doing with VoteER and the Civic Health Alliance. And finally, thank you for being here and all that you do on behalf of your patients. We hope that you'll become, again, an official member of DFA today and take a look at the benefits of the membership on the DFA's website. The #1 reason doctors, medical students, and other health advocates join DFA is to be with like-minded people that share the same values and priorities. And that's really centering public health and our healthcare around our patients and not other stakeholders. So thank you so much for attending and have a great night.